So you may have seen interesting new statute with a lot of sexual harassment related provisions in New York. And it's a statute that's more about various aspects of litigation than it is about things that employers need to do proactively. But whether you have employees in New York or not, it's tracking things we've been talking about. I think that we will continue to see both in the legislatures and the courts. So I want to just make you aware of a couple of them in particular. The first is the elimination of the severe and pervasive standard for what constitutes unlawful harassment. We've talked about this other times. The standard comes from U.S. Supreme Court decisions and generally is sort of trickled down to states and other courts that in order for harassment to be unlawful, it has to be severe and pervasive. And the way that standard has developed, it's proven to be a pretty high standard. So you see some behavior that I don't think anybody watching this video thinks is acceptable does not meet the severe and pervasive standard. One of the things I've been saying is that because it's a term that doesn't lend itself to precise definition, I think courts, judges, juries have room to interpret that standard to become not quite as hard for plaintiffs to meet, and that's something as employers we need to be aware of. But New York has just done away with it, and we've seen that potential in other states. Don't think we're likely to see it on the federal level, but I think we'll probably see it other places because that is a high standard. I think you can probably get consensus in a lot of places that the standard should be lower. So New York has replaced that with employers will be liable for harassment if it, quote, subjects an individual to inferior terms, conditions, or privilege of employment because of the individual's membership, unquote, in a protected class. So seems like a lower standard than severe and pervasive. As with anything new from a court or a legislature, how courts interpret it going forward will really give it life and tell us what it means. It does say that employers may have the defense that conduct is not harassment if it doesn't rise to the level of what a reasonable victim of discrimination would consider to be petty slights or trivial inconveniences. So it does say, as is the case now, not anything is harassment. So we'll just have to see how that develops. That's very significant. Obviously, New York is a significant state as far as population and employers and such. The other thing I want to point out, and these are not the only aspects, but I think these are two to keep an eye on, is generally, since those same U.S. Supreme Court decisions in the mid to late 90s, employers generally are not liable if an employee does not bring harassment to the employer's attention or the employee unreasonably failed to take advantage of the employer's processes. We talked in an earlier tape about a Third Circuit Federal Court of Appeals case where a court seemed to sort of give a little leeway in that in a situation where you had a reportedly pretty bad actor. Sort of the idea that the employer should know about it even if it didn't know about it. And I thought that's a direction we may tend to go, is that employers will be expected to know more about what's going on even if it's not reported and figure out how to find out. And I still think that's the case. Again, New York has just changed that, in part at least legislatively, said that the fact an individual didn't make a complaint is no longer determinative as to whether the employer is liable. So for most employers, I mean, certainly you should check with counsel about this. For most employers, this does not lead to a directive that you should go do X and Y. I think these are two really important themes and aspects of harassment that we'll continue to see develop here in the months and years ahead.